His work aims to describe the change that occurred in inheritance law in Italy during the 20th century, spanning both the fascism and the republic. It is precisely in this temporal framework that the new Italian civil code emerged. In 1942, the legislator saw the document to profound social change affecting the country and to address the new need the society demanded. From this perspective, inheritance law takes on fundamental importance when considering the transformation of both European and Italian socio-economic structures, which were a result of the First World War, but also of increasing urbanization and industrialization that marked the end of a predominantly rural society. This period was rich with family-run business, family units dedicated to farming and its broad exploitation, as well as to entrepreneurial and industrial activities. These were domestic managed realities lacking bureaucratic and managerial levels, with tasks reserved for the head of the family, and where entrepreneurial success was linked to the family financial solidity and reputation. In this light, it's possible to understand the new law provision that would regulate the subject. Italian inheritance law played a crucial role in preserving large family fortune and facilitating property transfer. The role of Filippo Vassalli within the Royal Commission for the Reform of the Code is difficult to determine given the breadth of his commitment and the sharpness of his contribution. It is certain that Vassalli played a fundamental role in drafting the title related to marriage and legitimate succession, as well as those concerning the book delle obbligazioni del lavoro, on obligation labor. Moreover, Vassalli's work was always divided between academia and legal practice, and the archive where his documents are preserved, drafted in his capacity as a lawyer, not only testifies to the depth of Vassalli, the lawyer, but also to all succession law, matters kept to courtroom busy. Indeed, the Vassalli archive contains disputes related to inheritance law. For example, the case brought before the Court of Appeal of Ancona in 1940, discussing the institution of an heir condition on marriage, which reveal the testator's intention to prevent the estate from being allocated to the daughter's mothers and thus outside the original family orbit. Another case between the Count Mario and Pia Tolomei di Lippa against Mr. Giovanni Porta concerned the recognition of the paternity of a natural child, requiring, as expressed in the memorandum before the Court of Cassation of the Kingdom, an explicit written declaration. Of great interest is the case before the Royal Civil Tribunal of Caltanissetta involving Count Vincenzo Testasecca and Marquis Paolo Malvezzi Campeggi, with lawyer Luigi Carnacini as the curator of the unborn and the Marquis Malvezzi's daughter. In the authorized note presented by Vassalli, the family and the business history of the Testasecca family is reviewed. The family was under the administration of Count Ignazio, though distinct from that of his son Count Vincenzo and his wife Marchesa Dora, and offering a point of reflection on the context of Italian business dynasties. I quote, the testa secca administration was one of those typical Italian administration of large families that retained the best of past tradition, namely the uniqueness of administration under the head of the family supervision with the collaboration of all its members. Thus, a healthy economy of expenses was achieved, and the head of the family's greater experience benefited all its members, while keeping separate and distinct the business and initiative of each. The note precisely describes the landscape of that time. Business dynasties where the family had managed the activities and the family wealth with balance. However, as the analyzed case demonstrates, prudent management of assets and lifetime donation or testamentary bequests were not enough to prevent family matters from reaching the courts. The note then examined the rule related to testamentary succession, legitimate succession, and necessary succession, the last of which, necessary succession, Vassalli defined as succession against the will, as a limit and corrective to testamentary succession that operates when the legitimate claimant feels harmed by testamentary disposition, before and rather than by lifetime donation. Necessary succession necessarily presupposed the existence of the testator's disposition. Issues related to succession rights for spouses and natural children, the validity or interpretation of wills, the capacity to make a will or imposition of condition, and inheritance disputes for family business management highlight the strategies for preserving the state mentioned earlier. By the late 1850s, Italy, still divided into several small states, exhibit marked political fragmentation matched by corresponding legislative diversity, affecting both public and private law. After the repeal of the Napoleonic Code in 1840-1850, a new codification process began, still largely inspired by French model. It was only in 1865 that the pressure for rapid unification of the kingdom led to the promulgation of the Civil Code. Although this code contained innovative provision, it still reproduced the guiding principle and the structural framework of the Napoleonic Code. Given the consideration above, it's not surprising that succession regulation was placed within the section of the code dedicated to acquisition and transfer of property and other rights over things rather than having its own book. The legislator, too, criticized for not deviating from the French model and thus from Roman tradition, did make a significant modification in succession law, both regarding wills and the succession of spouses and natural children, always with an eye toward preserving the state by transferring it within the legitimate family. In the 1865 Civil Code, legitimate succession is preferred over testamentary succession, as highlighted by the normative provision. This disparity is explained in a report by Justice Minister Giuseppe Pisanelli, which stated that legitimate succession is a social necessity, while testamentary succession might not occur. Experience show that the former is the rule, the latter an exception. The legislator choice seemed oriented toward privileging blood and family affection over other forms of testamentary disposition. The norms concerning legitimate succession are clearer and more accessible, while the freedom of the testator to dispose of their property is expanded with respect to the quota reserved for closer family members. Additionally, the pre-unitary code provision favoring the complete preservation of the estate, attributing ownership to a single beneficiary and excluding other potential heirs were eliminated. Despite this, the will remains favorable, regarded as a means of expressing individual determination. It can be seen as an affirmation on the individual's autonomy in disposing of their property after their death, as demonstrated by the restoration of the holographic form, which was previously abolished. In this perspective, society maximizes individual freedom, supporting every legal means that promote it. The measure of the modernity of legal system is often reflected in the protection afforded to its most vulnerable subject. The position of the spouse and natural children in the division of the inherited estate has long been a topic of debate and contested achievement. Even before the Unitary Code, legislators had progressively expanded in line with the prevailing notion of legitimate family within the liberal model, the inheritance right of spouses and natural children. The 1865 Code was no exception, making significant intervention on this issue. The turning point arose from differing conceptions of the family. On one hand, those who aimed to protect the family unit as an ethical organism and a true institution with a specific social role. On the other hand, those who argued that natural children should also have rights as they were innocent of fault of being born out of wedlock. The solution was a compromise, as reflected in Pesanelli's own word. The natural child has the right to claim a name, a family, and support in society. Therefore, denying inheritance right to natural children would mean committing an indignity to the bond of blood and to the moral and legal principle that everyone must bear the consequences of their action. However, as previously mentioned, the solution was a compromise considering Pesanelli's further statement. Equating the natural child to the legitimate would be considered an outrage to the legitimate family, which is the foundation and the basis of society. The inheritance right of spouse also underwent a positive change. The requirement of the limit of poverty present in some pre-unitary code was eliminated. The shares for the surviving spouse were increased. The participation of the surviving spouse with deceased relatives was restricted to the 6th degree, and the reserved share was recognized, although always in usufructo. The provision of the code, both those of 1865 and those of 1942, reflect a vision of the family based on marriage and meet the need to keep the estate within the original family, even extending to the 10th degree, sometime at the expense of the surviving spouse. The 1942 Code also intervened to soften the strictness imposed by the 1865 Code, while still adhering to tradition. The conflicts also arose concerning the more political aspect of the issue, the equality of the spouse and natural children. Regarding the spouse, the question of equality focused less on the opposition between natural and legitimate families and more on the coexistence of an extended legitimate family with a nuclear legitimate family, the solidarity it is among relatives and the need to maintain the integrity of the original family wealth. The goal was to prevent the asset from being transmitted outside the family, particularly in case of remarriage or absence of descendants, without excessively sacrificing the emotional sphere and providing adequate economic support to the widow. For this reason, there was resistance to abandoning the usufruct system and equating the inheritance right of the surviving spouse to those of other members of the immediate family. The legal framework had a significant influence on family business. Family capitalism was also encouraged by this inheritance transmission mechanism, strengthening the family governance within the business, preventing the erosion of the company's unity and the entry of outsiders into the family business. In drafting the new Italian Civil Code, the debate focused on reconciling the different trends related to the recognition, or more accurately, the expansion of inheritance right for spouses and natural children. The counterbalance to the desire to be in line with contemporary times and to address the demand of real society was the need to reinforce to legitimate family, also considering the idea of family inherited from the fascist regime. The commission responsible for drafting the book on succession, which, unlike the previous formulation, had acquired its own section within the code, was chaired by Mariano D'Amelio and included Filippo Vassalli among its members. Vassalli considered the innovation serious and profound, although he acknowledged that the traditional principle had not been overturned. This part of the draft was explicitly described as the result of a compromise between humanitarian sentiment, which demanded the equalization of inheritance right, and family order, for which any facilitation granted to natural children resulted in a weakening of the institution of the legitimate family. The intermediate solution was to improve the inheritance treatment without reaching the equality of rights, so as not to overly threaten the position of legitimate children. Indeed, the offer made by the Commission in drafting the project did not hold the mark. In its final version, the 1942 Code aligned itself with tradition, albeit in an innovative direction. This compromise was also dictated by the need to respect private property while affirming its social character, in accordance with the vision of the regime. Vassalli did not fail to point out the contradiction, but also to claim the many impulses for renewal. If little of this project can be found in the appearance and the structure of the new code, the contribution they made to the reform now implemented should not be overlooked. Vassalli continued by underlining of the technical amendments prevail over the substantial innovation, but that, in any case, the reform had kept the succession of asset firm as an explanation of the right to private property, having in any case acted on the measure of the available share on the measure of the rights of the spouse and natural children. Society was changing, and this was certainly not lost on the Commission, as well as on the universities, the professional order, and the judiciary, which were the first to provide opinions and the last to interpret the reality through their rulings. The role of women within the family was also beginning to receive recognition, where it was deemed appropriate to grant inheritance right to the spouse. Today's family is no longer the same as it was 50 or 60 years ago, when it was still inconceivable to consider the woman as a true partner and assistant to the husband, let alone as a professional. There were, of course, controversies, especially from those who believed that the chased asset should remain within the original family in order to continue the name and preserve the wealth within the patriarchal family, thus avoiding the transfer of asset to a family stranger. Thank you.